Welcome to The Straight Dope, where you hear the real talk about Iowa Vice. So Carl Olsen is back on The Straight Dope, and if you are new to the podcast and haven't yet seen the first two episodes, Carl and I covered a ton of stuff, but 20 tons of marijuana, you definitely need to check out that. And then the developments in the Iowa Religious Freedom Restoration Act, that's the second part of it. Both of them are bangers, but we're going to talk today about litigation that Carl's involved in, trying to establish the administrative rules for the religious use of controlled substances. And so, Carl, welcome back to what is now part 3. You're the most popular guest on The Straight Dope. So,
all right.
Yeah, thanks for coming back.
Yeah, thank you for having me.
Absolutely. Couple of things. Since we've last spoke, when we introduced people to the Ethiopian Zion Coptic Church and your involvement in that, I understand that there's been some press have reached out to you, and some documentary filmmakers have also reached out. Maybe if you could tell us a little bit about what's gone on since you were last here and that.
Yeah, as far as that documentary goes, one of the members of the church moved to South Africa, and he did a series of podcasts. Yeah, I think they were just audio. He did 10 of them, an hour each, and described the whole thing that went on in Jamaica that I wasn't really close to. I went to Jamaica a few times, but I didn't live there all the time, and he did. And it was really well done. It was professionally produced, and somehow some documentary crew latched onto that and went down and interviewed him for this documentary, and then he referred them to me to get my take on the whole thing, because he knew that I'm actively involved in talking about this, and so he knew I would be willing to participate, or kind of figured I would. And then I told him to interview Barbara Blake Hanna down in Jamaica, who was a Jamaican senator at the time all that was going on, former TV personality in Jamaica, currently on the Cannabis Licensing Authority in Jamaica. And then Dr. Melanie Dreyer, who was an anthropologist that lived with us in Miami, where I lived, and in Florida, and then wrote about a book about the use of cannabis during pregnancy, which is really controversial to this day, and published research on that. And I can't remember, she was dean of nursing at the University of Iowa. She's currently on something at the Rush University in Illinois. She was at Amherst for a while. She's taken over some cultural thing at Columbia University just recently. Anyway, extremely knowledgeable person, so they're going to interview her. And I sent them to one of my co-defendants from the 20-ton case in Massachusetts, and there's a picture of him and me back in 1980 on the steps of the courthouse in Portland, Maine, federal courthouse, sharing a joint and the bailiff in the background calling us back into the courtroom. So anyway, those are the people that I volunteered to be part of this documentary, and who knows where it'll spiderweb off from there. So I don't know when I did a 90-minute interview on Zoom, and then they wanted to come to Iowa, and I said, well, I don't have any place to put these people, and it's
We should do it here.
Yeah, but I don't know if they want to. I don't know what their intentions were. I just told them that I spent the last 50 years and everything that I have to litigate this case, and I'm not set up for entertaining. I'm not running a church. I'm being deprived of the right to participate in religious activity, and so my whole thing is I'm in the midst of a fight, a battle.
So we'll have that to look forward to. It sounds like that could be, it's not going to be tomorrow, but there'll be some video, some piece involving you with that.
Yeah.
To continue that story.
Yeah.
Cool. Well, I know that when we last spoke and we were talking about the Religious Freedom Restoration Act, the new statute in Iowa, we had touched on an administrative process that you're involved in, and I wanted to visit more in depth today about that, because it is the only action undertaken that I'm aware of that would attempt to establish administrative rules for a religious exemption for the use of controlled substances based on the peyote exception in the Iowa Code. And so maybe if you could tell us, what was the thought process about starting that application or petition for rulemaking? Why did you start it? Who did you file it with?
Well, the federal peyote exemption has been around since 1965 or 66, and Iowa added one by statute in 67, verbatim, identical. Just copied a federal regulation into the Iowa statute, then perpetuated this in 1970 into the Controlled Substances Act. So that religious exemption is an administrative process at the federal level. And the Uniform Act that all the states adopted recommend it be a administrative process.
And so Iowa certainly followed that when it adopted its.
And Iowa specifically chose not to.
Right.
And they actually put some legislative history behind this, and they did a drug abuse report or something like this. And in there they said they were not going to adopt the administrative procedure recommended in the Uniform Act and in the Federal Act. So it's not accidental, it's intentional. So the question is, can they do that? And I would say the answer to that is no, they can't eliminate that because they broke a rule. They put a religious exemption in the statute. That makes it unconstitutional if they don't allow other people to apply.
And explain, we touched on it a little bit, but explain what makes the specific provision of a religious exception in the Controlled Substances Act, what makes that unconstitutional?
Well, it's not unconstitutional on its face because the original list of controlled substances was statutory, and then the administrative agency was allowed to amend that list. The same thing with our medical law here. The original list of medical conditions can be updated by administrative rule. So simply putting a statutory exemption doesn't instantly make the thing unconstitutional. It's when you deny anyone else the ability to apply for one that makes it unconstitutional. So I'm saying that it's unconstitutional as it's being applied to me.
Because the one that's currently, and I suppose it's debatable whether or not they have actual administrative rules for it, but at least the exception itself just deals with peyote and the Native American church, correct?
Right. So the final decision from the agency does not say anything about an existing religious exemption. So the denial of my application simply makes it sound like this is the first time that anybody's ever asked for a religious exemption to the Controlled Substances Act. So it's deceptive. The final decision that I got is not, it's just deceptive.
And so before we get to that final decision, what was it that you were attempting to establish when you applied for the rules? What were you looking to do?
I was saying that I should be able to apply for a religious exemption because the state has created a statutory program for medical use that's inconsistent with federal drug law, but in the Controlled Substances Act, they added an affirmative defense for it. In Iowa Code 124-401-5C, it refers to this chapter saying if they've got a medical marijuana card, then they're immune from Chapter 124. And then the federal and the state enacted a farm bill that makes THC legal, and so now they remove THC if it comes from hemp from the Controlled Substances Act, wrote an exception for that into the chapter, 124-204-7, subparagraph 7, which refers to a Chapter 204, consumable hemp products. So the THC in marijuana is the only reason that marijuana was ever made illegal. So they've basically undone every justification for making marijuana illegal by making THC available in a grocery store as much as you can afford to buy, no limit on the amount you can buy. It's sold in a grocery store up the street from my house, like within walking distance of where I live. So you have to have standing to challenge, and that gives me standing to say now I have a real injury. Way back when I made an argument on peyote and they said my use of marijuana was unlimited, or my use of cannabis was unlimited, and that I had no restrictions whatsoever, and that wasn't like the peyote exemption, and peyote wasn't popular like marijuana, so the risk of diversion from my argument of unlimited use would be higher. Now, one of the dissenting judges on the D.C. Circuit Court of Appeals didn't buy that argument, so was that actually a valid application of religious freedom? I don't know, but anyway, I'm no longer making that argument because I have new arguments now.
So let's talk, and we talked a little bit about how the advent of the state's medical cannabidiol program, now where we have a secular use for cannabis that wasn't available at the time that you're making this argument on religious use or religious freedom grounds.
Yeah.
Now that you're no longer collaterally stopped from making those arguments because of this expansion of state law.
Right, and I don't think I would be collaterally stopped on an administrative asking for rules, because before I asked for absolute First Amendment immunity without any rules, okay? So since my claim is no longer unlimited freedom without any regulation, I think that also defeats collateral estoppel because it's not the same legal argument. But anyway, I have this combination of several things that defeat collateral estoppel, yeah.
Because what you're arguing for is if people are able to, for example, the medical use program in the state of Iowa, if people are able to buy products containing THC that's extracted from marijuana, and if they have a secular use purpose for that enables them to consume that you should at least have a right on a religious basis to have access to whatever they have access to.
Yeah, but you also have to factor in how weird this exception is. In 2014, they allowed possession, but you had to get it from out of state. So they're saying you have to go get this out of state, bring it in across state lines in
Sounds
violation.
like trafficking.
Yeah, exactly. So that was really weird. It's not just it's not just any old secular exception. It's a huge hole in the whole argument. And then in 2017, they had cultivation and distribution on top of that. And then in 2020, they removed the cap on THC, so now we have a product that's 80% THC in a vape cartridge, 1.5% CBD, and the rest of it is, I'm not sure what else they put in there, but no one's died from it yet, and there haven't been any adverse events from it. I'm not going to say it's safe, but it certainly hasn't been shown to be. I'm not sure if it's safe or not. How would I know? It looks completely safe, but I wouldn't want to try that. It wasn't my custom to use 80% THC in a vape cartridge, but that's how weird that is, and so I guess that covers it. So they keep making it, and the whole time I keep telling them you need a federal exemption for this. And there's precedent for that because they have a federal exemption for peyote. If the members of a church are a worthy cause, then certainly these people we're trying to help who have severe medical conditions have a worthy cause. And the DEA can't say it's not in the interest of public health and safety, especially now that they're recommending reclassification of cannabis based on that.
Into Schedule 3 out of Schedule 1.
Schedule 3, yeah, dropping 2 schedules because it has proven medical use. I mean, according to the Secretary of Health and Human Services, they came up with a new test they'd never used before, but of course, they never were confronted with a situation where this many medical professionals in 47 states are actually involved in working with patients using this stuff, so there's just nothing like it. And so they came up with a new standard because they couldn't have created this new standard before. There was nothing like this before. The DEA objected to that. Secretary of Health and Human Services had the Office of Legal Counsel do a review. The Office of Legal Counsel, which is higher than the DEA, overruled the DEA and said you have to accept this new standard. So now it's being reclassified based on that being the evidence that it has medical use.
And so when you file this application,
And of course, through all of that is no serious injury to anybody.
so they're able to, so is that the same standard that they were using to determine whether cannabis had accepted medical use in the United States, or this is a new standard under
The old standard was either FDA marketing approval or completion of a 5-part test, which they had a terrible time establishing. They went through 3 different iterations of this 5-part test back in 1994. 1991, they came up with an 8-part test. The court didn't accept it, said several of the things were impossible to meet. They came back in 94 with a 5-part test, and that test has been used since 1994. Well, 1996 was the first medical marijuana law, so
California.
how long does precedent last if it's based on a factual situation that's no longer the same? So the DEA argued that they had this precedent, and the Office of Legal Counsel overruled them, saying, your precedent doesn't cover this. You have to accept the Secretary of Health and Human Services opinion on this. So now there's a new test that says if it's widely used for medical purposes under the supervision of licensed medical professionals, and it has been proven to be valuable for different things. Like the UN reclassified it in 2020, saying it had medical value. I can't remember some national thing did a study, Academy of Science, I think, did a study, said it was useful for pain, that it had proven value for pain. So there's enough there that the Secretary of Health and Human Services was able to put together justification for this new this new test for currently accepted medical use.
Put it into Schedule 3.
And it can't be in Schedule 1 if it has currently accepted medical use. So then they went beyond that because Schedule 2 would work. They said it doesn't have the abuse potential for Schedule 2, so bump it down to Schedule 3. So that's quite a sea change there.
And so your application for administrative rules in Iowa, so it's a little different from what's going on at the federal level, but what are you trying to accomplish with that rulemaking petition? What was the goal for that?
Well, I want to establish that I have the right to use cannabis for personal private use. In 1972, when cannabis was classified in Schedule 1, it was so controversial that a commission was appointed by President Nixon, by Congress, to do a review of this to see if it was correct to be placing it in Schedule 2, 1, and they said it should not be criminalized, that personal and private use and sharing for none or small remuneration should not be criminalized, that only the commercial use should be prohibited. So I'm basically arguing for that, but of course one person can't share with anybody, so I'm asking for the same thing the commission recommended, but I can't make the argument beyond one person. That would be for someone else to come in and make the argument, and then there would be 2 persons, and then if those 2 persons wanted to share, they would have to have their exemption modified to say that eventually I would want it to end up where the commission landed on the issue.
So is your request for rulemaking, is there a religious component to that?
Yeah, but it doesn't, again, the government can't favor religion over non-religion. Now the whole thing is, though, is I don't have standing to make a non-religious argument because I have never made one. I don't even know exactly how you would make a secular argument, but I can't because I've already established that my argument is a religious claim, so I can only go that far saying you're discriminating, you're favoring one religion over another without any evaluation. I mean, where's the review? When did you do an analysis on what I'm asking for compared to the exemption that already exists?
And that's the peyote exemption.
Yeah, peyote hasn't been found valuable for anything but religious use since 1965, and here cannabis is going through all kinds of evolution. I want my day in court, but the administrative process is essential because those are your health experts. The court is informed by an evaluation by those agencies because they have the expertise to decide whether this is abuse or not.
And so when you filed that application for rulemaking, you filed that with the Iowa Board of Pharmacy?
No, I did not, because the Iowa Board of Pharmacy has very narrowly defined authority, okay? In section 201 of 124, it says they can evaluate these 8 factors, okay? And that they can recommend changes in the schedules. Well, the schedules are just one part of Chapter 124. There's a whole bunch more of Chapter 124 besides the schedules. So I didn't want to limit my argument to a scheduling change. Like the board could recommend the peyote exemption be removed.
Okay.
They could recommend that it be, that another exemption be added to that same schedule. That would be within the pharmacy board. But if there was going to be an application, that would kind of go beyond that. So I said the agency has broader authority. The department has the authority to file any legislation, not just scheduling changes. So I wanted to have the full advantage of that. And then, of course, the department came in and argued that it should be the board instead of the department, that I had sued the wrong party. And the judge said, well, he's suing the department, and you're here today and you're saying you don't represent the department? Well,
so
the department better send somebody.
What department did you end up suing? Or
The
for
Department of
rulemaking?
Inspections and Appeals and Licensing.
Okay.
Because they would be licensing, exceptions, registration, all this stuff has to do with the name of the department is Inspections, Appeals, and Licensing.
And is Health and Human Services or the Board of Pharmacy, were they brought into?
Last year during the government reorganization, they were moved from the Department of Health to the Department of Inspections, Appeals, and Licensing. So is there any logic, any consistency, like, what are we really doing? I don't know. I don't know why the governor thought that was a good idea or the legislature did that. But I'm saying that you can't change the nature of that board by moving it around from one department to another. It's still there for the protection of the public health and safety, no matter how you cut it.
So is it safe to say when you filed your petition asking for a religious exemption that you were able to get the benefit of the experts and all the medical review and all the religious review at the agency level? Did they give the rigorous review to your application that you were anticipating?
Well, like I said, they didn't admit that there's an existing religious exception. They made it sound like I was asking to be the first of its kind. And in that circumstance, they have case law, Employment Division versus Smith, that says if there's no exception, they don't have to create one. Well, then the existing exception becomes a critical fact in the analysis, because that's what the whole entire Employment Division versus Smith case was about, is that there were no exceptions in Oregon's Controlled Substances Act, and therefore they didn't have to create one for peyote.
And how is Iowa's different than Oregon's?
Well, Oregon had no exceptions, and Iowa had an exception for peyote. Now, Oregon has added exceptions for all kinds of stuff since then, and so has Iowa, but particularly cannabis. I don't know what all exceptions Oregon's added, but cannabis for sure. There's only 3 states that haven't, and I can't remember, Idaho and Nebraska maybe, and anyway.
So we've got that peyote exception. Is there any application to the fact that Iowa has a secular use exception for medical cannabidiol under Iowa Code Chapter 124E or the consumable hemp under Chapter 204? Do those play into it?
Well, those create more disparity. I'm being denied religious freedom while other people are being held to be more worthy. You know, they're saying that a medical condition is superior to a religious practice, and that's not the case. They're supposed to have equal, I wouldn't say greater, but equal.
On par, equal.
Yeah. Religious freedom is considered, I mean, it's in the First Amendment, it's fundamental. There's no right to health care or medical treatment in the Constitution. I wouldn't belittle it. Maybe
Sure.
right to life and liberty, whatever. I don't know, is that in the Declaration or the Constitution? Anyway. And then the secular use of THC being legal at both the federal and state level. The only reason cannabis, I want to say, the only reason cannabis is made illegal is because it had THC in it. And now the only thing you can have is pure THC, but you can't have the plant it comes from. It's getting to be absurd. And yet there's no recourse for a religious claim. Like, you can't make one. Now you can. The Religious Freedom Restoration Act creates a private cause of action to enforce this right, which didn't exist last year when I filed this case. And that allows you to bring an action, private, personal action against the government, both judicial and administrative. So it completely fills in all the missing gaps now, and they are absolutely obligated to listen to me now. But the thing is that the restoration, the Religious Freedom Restoration Act, restoration doesn't mean the creation of something new. It means something that has been left out by the judiciary and the executive branch. So the legislative branch is telling them, hey, you guys are not doing your job here. You're not vigorously protecting religious liberty. Cut it out. We want you to start paying attention to this. So it's a rebuke of the judicial branch and the executive branch for not protecting this first freedom. And because of that, I think I can ask for an administrative remedy, because I want the court to have the benefit of the administrative analysis before the court makes the final decision, and the court is not bound by the final decision of the agency, the same way that Loper Bright Enterprises versus Raimondo, that was decided in, June or July, by the U.S. Supreme Court, said that the courts are not bound by agency decision-making, but they...
Chevron doctrine.
Yeah, but they need to give it great respect, because obviously you want to have the agency supply whatever input it can into the situation before the court gets it, because the court may not be an expert in these areas, and it wants to see all those things thoroughly vetted before it gets dumped on the court. So the Religious Freedom Restoration Act covers both, and that case Loper Bright describes how the court benefits from the agency decision even though the court is not bound by it.
So when you make that application for administrative rules for a religious exemption, this is before, obviously, the developments in the Supreme Court, but it's also before the passage of the Religious Freedom Restoration Act.
Right, but I'm certainly not aware that I'm certainly not unaware of that these two issues have been percolating for a while.
For sure.
So, Iowa's number 28 state Religious Freedom Restoration Act. So, and that comes from City of Bern versus Flores, where the Supreme Court invalidated the part that applied to the states. So as soon as the Supreme Court did that in '97, the states started saying, well, then we'll enact our own to make up for the loss in City of Bern versus Flores in '97. So I could see that was, and the previous legislative General Assembly passed the Religious Freedom Restoration Act in the House 93-1, and it didn't become law. Well, that almost guaranteed it was going to come back this year. There must have been something they didn't like about how they wrote that one, and they wanted to come back with a stronger one. And sure enough, you look at the one 2 years ago that passed 93-1, it was really weak. And the one that they just enacted is stronger than anything I've ever seen. It was the most well-written Religious Freedom Restoration Act I've ever seen. And I've looked at the other 27, so I've never seen, and even the federal one isn't written this well. Now, the Supreme Court has added interpretation to the federal one that brings it up to the level of the Iowa one, and that's why the Iowa one is written that way, because they have the advantage of seeing the Supreme Court saying that it does create a claim for damages. Okay, federal one doesn't say that, but the Supreme Court said yes, it does. So then Iowa just put damages into ours because the Supreme Court had already declared that's what it means. I can't think what else, but anyway, that's how we got ours. And then the other thing about deference to agency decision-making, the attempt to overturn Chevron has been going on and has that same momentum. Yes. So because I follow this stuff, I wasn't totally unaware last year of the potential for all this stuff kicking in while my case was pending, and it did.
So when the agency ultimately denies the relief that you're requesting, mm-hmm. and you then appeal that agency decision out of the agency into Polk County District Court?
Yeah.
Okay. Where are you in that process with the agency review?
Well, I filed an opening brief in February, and it wasn't, you know how the court will issue a briefing schedule? I didn't wait for that. I just filed a brief with my complaint. Okay, so I filed a complaint and a legal brief with it, which is, I asked you about that. Yeah. You said that's totally cool, you know?
Yeah.
So that's in February. And then in April, the Religious Freedom Restoration Act is passed. So I started filing notices with the court saying, hey, there's been a change in the law here. Hold on here. This is like, there's something going on here. And then in May, they passed this 10 milligram thing on the THC.
And just so everyone can track with that, what you're talking about now is the consumable hemp,
yeah,
which is not a secular use issue.
Climbing kites, the can of soda.
So it's all of that, and there's litigation going on right now.
Yeah,
to challenge the new laws and regulations.
Yeah, so saying 10 milligrams is too low or whatever, you know.
Right.
And it interferes with interstate. The weirdest thing that Congress did was made this absolutely, you can't interfere with interstate commerce. You can't interfere with the shipping of these products from any of the 50 states to any of the 50 states.
Correct.
So when Iowa adds a 10 milligram cap, if Minnesota set a higher cap, I can't remember what states there are, but if a state set a 1,000 milligram limit, then they can ship those products around the United States, and our 10 milligram limit doesn't really hold water. So you can see what a mess that is. But anyway, I don't care because it makes my argument, and my argument is not for THC. I want the plant with
Correct.
The THC in it, which is nowhere near that high a concentration. Well, I shouldn't say that, but anyway.
And so you're in the middle of briefing.
You don't use cannabis that way. You smoke it till you get high. You're not going to take 1,000 milligrams of THC.
And just so people that haven't seen the first two episodes, this started with your religious use of cannabis is a sacramental use that involves smoking. It could be in an edible preparation, but primarily
it can be in any form, but it was primarily in a smokable form. And if you read the Bible, it talks all about the cloud and the incense and the censer and the angel's hand and you know, in the clouds, and it just the burning. It's just over and over again in the Bible it talks about a sacrifice, you know, a sacrament.
And, you know, and now that I think about it, thinking this through for the first time, we've got edible forms of consumable hemp, but we don't have smokable form. In fact, that's criminalized still.
Right.
Smokable hemp, you cannot consume it even though it's
right.
0.3%
yeah.
Delta 9 THC.
I think in Minnesota they're trying to add a thing that's saying it can't be smoked in public, and they're trying to add tobacco to that so that it's consistent. Like, we just don't want smoking in public. It's not that we don't like marijuana. We just don't like smoking, you know, which is fine with me. I'm not going to try to smoke it at your house.
Right. So if you've got a briefing schedule that sounds like it's maybe coming to a close. Oh
yeah. So then so then the court had a hearing when the state tried to substitute the board for the department. And at that hearing, the state attorney couldn't make a cogent argument, and the court said, well, it says here an agency, and the department's an agency, and the board's an agency. What's the difference here?
You're here for the agency.
And you signed up for the department, but now you're saying that you don't represent them, you represent the board. So she didn't do very good. She was late for the hearing too, and the judge was joking with me that he was just going to dismiss her motion until she showed up, and he hasn't ruled on that motion. So now she's making an argument that she represents both the department and the board. So she has conceded that point by doing that.
And that, you're working on a reply brief?
Okay, so then the court asked me to at that hearing on May 10th, okay, the judge asked me to file a new brief. He said, I don't want to rule on your brief.
Because it didn't have Religious Freedom Restoration.
You didn't have the Religious Freedom Restoration Act in there. I want a brief that has everything in it. Could you write a new brief? And gave me until August or July 1st. Okay, gave me until July 1st to file my opening brief. I filed it June 20th, so I gave the state an extra 10 days. Then she forgot to file a reply and asked for an extension of time and filed her reply on the 9th of August. And then my response, my final brief is due September 1st.
And then will there be an argument for that, or will the court?
Yeah, the court has scheduled oral argument for that for September 13th. Yeah.
So we'll have some developments probably next quarter on that.
Yeah. And of course now the Religious Freedom Restoration Act allows me to go directly to court. So if the agency somehow escapes, I can't imagine that the agency is going to get let loose here, because the Religious Freedom Restoration Act allows me to file judicial or administrative, and I would prefer administrative because you get the court after that. You get the best of both of them.
Right.
But if the thing goes south, then I've got an original action for declaratory and injunctive relief now under the Religious Freedom Restoration Act. And plus I've developed quite a record here so that no one can say they didn't see this coming or they didn't know about it or whatever.
Now, and I'm somewhat familiar with the process that you've been through right now, but at least for viewers, that they understand that these constitutional claims that you're making, up to now, the agency itself has not been ruling on those constitutional claims. It's been acknowledging them that they're filed, but there's precedent.
Okay, there's a lot of precedent saying that the agency can dodge the constitutional question.
Right.
But that it's preserved for judicial review. So that means that you have to fully present your constitutional argument to the agency.
Even though you're not going to get a ruling on it.
And they ignore that.
Right.
And then you preserve that for judicial review without any agency analysis.
Which would benefit the court, presumably.
Absolutely.
They're the ones to review the record. The record's developed before the agency. They're applying legal argument to it.
So the same way I got through describing how the DEA said there was precedent that they couldn't accept this new test from Health and Human Services, and they were overruled, and Office of Legal Counsel said your precedent is impermissibly narrow. Same thing. Just because it's precedent doesn't mean it's legal.
That's a great point.
That's unconstitutional. Yeah.
So it'll be something that we could look forward to. You'll have this claim now fully developed in a venue that can properly hear it and decide on it. So it's something that we'll be paying attention to.
And if I don't win the case, then I would be like, do I file with the Iowa Supreme Court?
Certainly, that would be the next step in that judicial review process.
Or do I just come back to the agency and file a new claim based on the Religious Freedom Restoration Act? Or do I go to court and file an original action based on the Religious Freedom Restoration Act? Which of those three options is the better option? Or are all three simultaneously the best option? I mean, this is, yeah.
Right, and you are the first person that I'm aware of because of the newness of the law, and obviously you've been a trailblazer for 50 years on these issues, so it wouldn't be surprising that you'll be the first one litigating these issues with new law.
No, because I was anticipating it, like I told you. I wasn't unprepared for it.
Right.
I was expecting it. I didn't expect it to work out quite this good, but whatever.
Well, I know we're obviously always interested in hearing, how this continues to progress and new developments. So, I'm going to be inviting you back to give us the latest on that.
And it's interesting that documentary crew got interested in it right at this moment. Well, I have this thing percolating where there might be something interesting to put in the documentary.
Absolutely.
Yeah.
So, Carl, I want to appreciate you coming in again today. Look forward to having you soon. Thank you.
Yeah, thank you.